Welcome to Doug in Exile. We cover the Supreme Court, all the major cases, and they're in session. So there's going to be a lot of these pounding out. I've got a number of them here in this episode.
Also this, moments ago, breaking at the Supreme Court, the justices there have issued a decision on Tennessee's ban on sex reassignment medical care for minors. The Supreme Court upholding the Tennessee law that bans certain types of gender-affirming care.
First, the good news. Here it is. This is a Supreme Court. Justice Ketanji Brown Jackson disclosed receiving over $2 million from her book deal with Penguin Random House. Now, this is a bit of gossip before we get to that big Supreme Court breakout, because remember how all the Democrats went nuts on Clarence Thomas getting personal favors and monetary kickbacks from personal people. And they were implying that he should be impeached, he should be removed, he should be replaced. Well, now Ketanji Brown Jackson has disclosed a $2 million book deal with Random House just last year. Now, to put that in perspective, she got $2 million in this last year. Clarence Thomas has gotten a total of $4 million in favors since he got on the Supreme Court in 1991. Okay, so she's made up for half that money here. I'm just listening to the silence of Democrats asking her to step down, asking her to recuse herself, asking her to be replaced. Of course, that's not going to happen. Let's keep going here. Okay. This one is breaking. The Supreme Court has upheld Tennessee's ban on transgender surgeries and hormone therapies for minors, underage kids. And it was done by 6-3, of course. The female woke justices were against this. They want to change the gender of your kid and give them hormone therapies, though they don't really have a say, at 12 years old. That's leftist propaganda politics on that side of the bench. I do want to note that Amy Coney Barrett, who has been going along with them, did not go along with them on this one. This is a huge win for children. All states just received the green light to get on board. So now you have other states will hopefully be joining this thing. This is what the document looks like. Let's get in on this one here. This says Supreme Court of the United States syllabus. This is the United States versus Skermetti, the Attorney General and reporter for Tennessee. Here's Mark Hemingway. This is Molly Hemingway's husband. Says, what on earth is John Roberts doing allowing this nonsense to persist? So this is I'm going to hit on John Roberts a lot on this episode too, because he really is, that court is not stepping up and doing its job, because when the Supreme Court won't weigh in, and so ultimately it's going to be John Roberts who's going to make the decision if they try this stuff or not, then, that silence just allows the Democrat judges from lower courts to step in and give Trump trouble and overstep their boundaries. Here's the statement. Defendants Marco Rubio, in his official capacity as Secretary of State and the U.S. Department of State, jointly the agency defendants, as well as officers, agents, employees, attorneys, and any other persons acting in concert with or behalf of the agency defendants, are enjoined from enforcing the passport policy, as that term is defined in today's memorandum and order. As to members of P1 class, the agency defendants are further enjoined to process and issue passports to members of the PI class consistent with the State Department's policy of January 2025, that's under the Biden administration on the 19th, and to permit members of the PI class to self-select the sex designation male, female, or X. That is different from the sex assignment to those individuals under that passport policy. This is an argument over that the Supreme Court punted on, that Marco Rubio tried to say that you have to put male or female on your passport. And now you can put or back then under Biden, you can put in an X, which tells you nothing about the person's sex. So it's dumb. So people are calling out now, where's John Roberts on this one? Here's Sean Davis. And all this nonsense is happening with the implicit approval of John Roberts. So this puts pressure on John Roberts, who apparently is fine with all of us assuming his precious little judiciary is a pathetic joke. Here's more on Trump's appeal of National Guard ruling to be heard Tuesday by the Ninth Circuit. That was yesterday. So this is about him using the National Guard in LA to cull riots. That another judge, lower judge, came in and slammed him, and now we need the Supreme Court to step in. There's a lot of this stuff that is calling for we need the Supreme Court to step in, including the E. Jean Carroll case that we covered yesterday. I have a little more on E. Jean Carroll I might get to later today, but it really is going to be the Supreme Court having to decide, Justice Roberts, are you going to allow these lower courts to override and undermine the President of the United States agenda? Because that's what you have right now. Lower courts basically having more power than the elected president, and judges are not elected. In general, they're appointed. Here's Lori Wyndham, more on the Supreme Court. Breaking: the Supreme Court just ruled in favor of nuns fighting New York's abortion mandate. New York has such a strong abortion mandate that you support it, or your hospital be part of it. And these nuns fought it, and New York stomped on them because they despise Catholics and they despise Christians. And it went up to the Supreme Court and they got smashed. The ruling orders New York courts to reconsider whether the state can force religious organizations to pay for abortion. See, it's one thing if you want the free choice to make your decision on abortion personally. In New York, you have to fund it. That's like forcing you to vote for it and forcing you to endorse it if you're paying for it. Here's Roman Catholic Diocese. So this is the actual words. The petition of a writ of certiorari is granted, the judgment is vacated, and the case is remanded to the Court of Appeals of New York for further consideration in light of Catholic Charities Bureau. Okay, that's more good news for freedom of religion. This is Charlie Cook on the Washington Post, had a really bad spin on that Tennessee trans case. Breaking: a divided Supreme Court cleared the way for states to ban certain gender transition treatments for minors, a polarizing national issue the Trump administration has seized on in initiatives targeting transgender rights. Trump didn't target them, you moron.
Yeah, and this has been one of the most watched cases of the entire term because there are many other states that also have some kind of limit or ban on trans treatment for minor children. So this has gotten a ton of attention, and essentially the court's ruling 6-3. There are concurrences and breaks here and there, but the majority opinion says this. They says this case carries with it the weight of fierce scientific and policy debates about the safety, efficacy, and propriety of medical treatments in the evolving field. They say there are a lot of different studies out there. They came up during arguments, some of them saying other countries have limited or backed off these treatments for minors, but they say that's not our place, our decision to make, but essentially says our role is not to judge the wisdom, fairness, or logic of the law, but just to ensure that it does not violate the equal protection guarantee of the 14th Amendment. They said this law survives that scrutiny. So essentially, concluding that it does, we leave questions of policy to the people, their elected representatives, and the democratic process, essentially saying Tennessee has passed this law. We're not going to step in. We think that it passes the constitutional muster of the 14th Amendment. So Tennessee can continue under this law to ban specific treatments that are trans-related for minors. And the other states out there, 20 plus of them, who have these laws will also take great reassurance that the court is signing off on what they've done.
Okay, now here's Charles C.W. Cook. He's a conservative over at National Review. This is all irrelevant. The reason the Supreme Court upheld the Tennessee law in Scarametti is that the job of the Supreme Court is to uphold federal law, including the Constitution, and there's nothing in either source that obviates the Tennessee law. So I'm just trying to show you how this has almost nothing to do with trans rights. What made the decision actually stick is more about federal law and the Constitution versus states' rights versus state law in Tennessee. Okay, now here's Ketanji Brown Jackson. In her own words, I like this from Breitbart because they actually quoted her, and I think that's actually kind of important to hear her speak. Breaking: Supreme Court upholds Tennessee's ban on transgender hormone disruption for minors, voted 6-3 with only Kagan, Sotomayor, and Jackson dissenting. Remember when Ketanji Brown Jackson compared the law to a ban on interracial marriage, which is a ridiculous ridiculous argument, but listen.
Being drawn by the statute. That was sort of like the starting point. The question was whether it was discriminatory because it applied to both races and it wasn't, necessarily invidious or whatever. But, as I read the statute here, the case here, the court starts off by saying that Virginia is now one of 16 states which prohibit and punish marriages on the basis of racial classifications. And when you look at the structure of that law, it looks in terms of, you can't do something that is inconsistent with your own characteristics. It's sort of the same thing. So
she's trying to say it's the same thing. It's not the same thing. This is apples and oranges. Okay. And I'm surprised that she would fall for this as a black woman. She's saying that your identity, that is saying that trans people are categorically different than what is going on with black versus white people. In other words, what is significantly different between blacks and whites? Purely your skin color. That is, these are genetic characteristics. These are not moral choices. It's not a moral choice to be black or to be white. However, transgender is a choice to change your mutilate physical characteristics. By the way, just because you cut parts off and put in hormones, that does not make a man into a woman, period. Science. This is science, guys. This isn't even an opinion. Now, what the court has to determine then is your own personal identity, the way that you choose to express yourself. And if I choose to express myself as a woman, I am now a woman, and now you have to recognize it. You have no choice to recognize it, because this is my internal characteristic. It's no different than me having black skin. That's what Ketanji Brown Jackson is saying. It's ridiculous. I just think it is a black person. A black woman is a completely natural occurrence. But the surgeries you have to have on a transgender person, that is not a natural occurrence. Neither is me claiming to be a female. If I walk around saying I'm a female who can have a period and have a baby, that is not a natural occurrence. That's not anywhere backed up by science, reason, logic, or anything. And so we had that argument at the Supreme Court, and Ketanji Brown Jackson lost this one. We're not out of the woods yet, because there's millions more things going around about these kinds of identity issues that I think make for really bad law. So it's good that the Supreme Court correctly rebuked Jackson, Kagan, and Sotomayor on this one. And then why not Amy Coney Barrett? She has gone soft on these issues before. Here's a Ann Coulter quote. She said, "This is a big mistake. As President Trump was leaning toward appointing Amy Coney Barrett to the Supreme Court 5 years ago, some advisors shared doubts about whether she was conservative enough, but he waved them away. Trump waved them away." And Ann Coulter's taken a shot at him, going, big mistake. Ann Coulter's wrong on this one. Amy Coney Barrett did not join them on this one. So this is a little bit of a defense of Amy Coney Barrett, not a big one, because I'm somewhat in agreement with Ann Coulter. It's just not black and white. No Supreme Court justice gets everything wrong, and no Supreme Court justice gets everything right. It's a mash of law that they're trying to figure out. Anyways, now you're all caught up on the Supreme Court. What do you guys think? Should Ketanji Brown Jackson get in trouble for getting a $2 million book deal? Should not all of the Democrats who called for Clarence Thomas to step down call for Jackson to stand down? Let me know in the comments below. I'm Doug in Exile.